Hello students, my name is Nisha Gera and I have recently accomplished LLM in Intellectual Property and Competition Law from Munich Intellectual Property Law Center, and I work in the field of technologies transfer, patents and competition law. So in this module we shall discuss about the evolution of competition law and policy of India, and basically the two major acts, the Monopolistic and Restrictive Trade Practices Act 1969, which we will call MRTP Act, and the Competition Act 2002, which forms a major role in the economic liberalization of the country as well as prohibition of restrictive and unfair trade practices along with the control of the dominant positions. So I will start with a brief overview of what is the relevance of the competition in an economy and what are the components of an effective competition policy. So competition law and policy forms an inherent part of the developing world to not only protect their domestic markets but also compete fairly and effectively in the international market. These policies have been very instrumental in fostering sustainable development as well as restricting anti-competitive behavior which inhibits economic growth. The implementation of competition law must be in coherence with the level of overall development in a country, since there is no one legal framework which would suit all the jurisdictions. The competition policy of India creates an active and viable environment for the industries to compete domestically as well as internationally with an aim to promote economic development using advanced technologies and an adequate capital. The government must play an active role in promoting economic liberalization by focusing on various policy issues such as foreign direct investment, licensing of technology, intellectual property rights and eliminating trade barriers rather than just following the conventional principles of competition law. Competition policy's main concern is that the corporations with market power are able to harm the interests of consumer, thereby curbing innovation. Although competition law and competition policy are used hand in hand, yet they can be distinguished. Competition law is a set of rules and regulations framed to promote competitive environment in an economy. Competition policy, however, refers to all the laws and changing government policies whose aim is to establish and maintain competition and remove restrictive trade practices. There are two main elements of an effective competition policy report. The first important aspect involves the incorporation of a set of policies which would benefit the domestic as well as international markets, thereby fostering competition. These would include the liberalized trade policies, ownership requirements and deregulation of economy. Another aspect is the competition law, which is designed to prevent anti-competitive practices and prohibit unnecessary interference from the government. In India, the policy is aimed at incorporating these policies into statutes in order to reduce the irregularities in the market and develop a healthy economy. So basically the competition law aims to prevent anti-competitive practices with minimal government intervention, and it also prevents artificial entry barriers, facilitates market access and complements other competition promoting activities. Since attaining independence in 1947, India adopted and followed policies comprising what are known as command and control laws, rules, regulations and executive orders. The competition law of India, namely the MRTP Act, was one such. It was in 1991 that widespread economic reforms were undertaken, and consequently the march from command and control economy to one based more on free market principles commenced its stride. The post-independence period had witnessed a certain level of industrialization amongst a class of people who managed to attain an entrepreneurial rank despite the misery and havoc caused by the colonial rule. The country wholly adopted the Indian industrial policy after the independence in order to promote and protect the economic development. The new policy also clearly defined the role of state in commercial development. Now let us first discuss about the constitutional provisions which instigated this effort. The Constitution of India in Article 38 and 39, which are a part of the directive, directs that the state shall strive to promote the welfare of people by securing and protecting as effectively as it may a social order in which justice, social, economic and political shall inform all the institutions of the national life, and the state shall in particular direct its policy towards securing that the ownership and control of material resources of the community are so distributed as the best to subserve the common good. Moreover, that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. Now let's talk about the key studies that triggered the shaping and sanction of MRTP Act 1969. Three studies primarily influenced the shaping up of MRTP Act. The first one is the Hazari Committee Report on Industrial Licensing Procedures. This was undertaken in 1955. This study stated that the states have been biased in granting industrial licenses only to the wealthy and influential entrepreneurs, and it has resulted in an uneven growth of industries. The second report was the Mahalanobis Community Report on Distribution and Levels of Income. This was undertaken in 1964. The second study was by a committee set up in October 1960 under the chairmanship of Professor Mahalanobis to study the distribution and levels of income in the country. The committee, in its report presented in February 1964, noted that the top 10% of the population of India cornered as much as 40% of the income. The committee further noted that big businesses houses were emerging because of the planned economy model, and it was practiced by the government in the country and suggested the need to collect comprehensive information relating to the various aspects of concentration of economic power. It concluded that the economic model was planned in a way that it supported the successful industrialists, and a handful of influential groups controlled a huge chunk of income. Let's come to the third study, which is the Monopolies Inquiry Commission report of Das Gupta. The study was undertaken in 1965. It was enjoined to inquire the extent and effects of concentration of economic power in private hands and the prevalence of monopolistic and restrictive trade practices in important sectors of economic activity other than agriculture. The Monopolies Inquiry Commission presented in its report in October 1965, noting therein that there was concentration of economic power in the form of product-wise and industry-wise concentration. The Commission also noted that a few industrial houses were controlling a large number of companies, and there existed in the country large-scale restrictive and monopolistic trade practices. As a corollary to its finding, the MIC drafted a bill to provide for the operation of the economic system so as not to result in the concentration of economic power. The bill provided for the control of monopolies and prohibition of monopolistic and restrictive trade practices when prejudicial to public interest. According to the study, the economic power was in the hands of a few commercial houses, and restrictive and monopolistic trade practices were widespread. The bill, drafted by the MIC and amended by a committee of the Parliament, became the Monopolies and Restrictive Trade Practices Act 1969 and was enforced from June 1, 1970. The Act drew its inspiration from the mandate enshrined in the directive principles of state policy in the Constitution, which aims at securing social justice with economic growth. The preamble to the Act says that the statute is enacted to provide that the operation of the economic system does not result in the concentration of economic power to the common detriment, for the control of monopolies, for the prohibition of monopolistic and restrictive trade practices, and for matters connected therewith or incidental thereto. The regulatory provisions in the MRTP Act apply to almost every area of business, may it be production, distribution, pricing, investment, purchasing, packaging, advertising, sales, promotion, mergers, amalgamations, and takeover of undertakings. Provisions relating to mergers, amalgamations, and takeovers were deleted in MRTP Act by the 1991 amendments to it. We will discuss this after a while. They seek to afford protection and support to the consuming public by reducing, if not eliminating, monopolistic, restrictive, and unfair trade practices from the market. Now, the main objectives of the MRTP Act were to prevent, control the monopolies, prohibit monopolistic trade practices, MTP, restrictive trade practices, RTP, and unfair trade practices, UTP. Now, the monopolistic trade practices, MTP, is a result of unreasonable pricing, limiting or restricting competition or no free market, limiting development, technical and economic development by limiting production and supply, making unreasonable profits. The restrictive trade practices is a result of refusal to deal with consumers, selective dealings, discrimination in pricing scheme, restriction of area, tying up sales. For instance, refusing to deal with certain class of consumers in relation to goods and services and offering discriminatory prices to different consumers. Coming to UTP, the unfair trade practice was incorporated in the statute after the Act was amended in 1984. This trade practice is a result of hoarding or destruction of goods, promoting false and misleading promotion contests, bargain sale, misleading advertisement, and false representation, free riding over someone else's reputation. For instance, the practice of making any oral or written statement which suggests that the renovated, repolished, or old goods are new. Now let's talk about certain provisions under the MRTP relating to monopolistic, restrictive, and unfair trade practices. Under Section 10 of the MRTP Act, the MRTP Commission is permitted to investigate into the matters related to monopolistic or restrictive trade practices on being referred by the central government. The unfair trade practices have been laid down in the Section 36 of the Act. The Act also lays down a provision for the appointment of a Director General of Investigation and registration to facilitate the inquiries carried out by the MRTP Commission as well as maintain records in relation to the restrictive trade practices. The MRTP Commission received complaints from the consumers, trade associations as well as individuals either directly or through different departments of the government. The Director General of Investigation and Registration investigated a case preliminarily when a consumer files a complaint. He was then required to submit his findings to the MRTP Commission for further investigation under the relevant provisions of the MRTP Act 1969. You could see a flow chart which shows the process of investigations carried out by MRTP in cases of the complaints as they are filed by the consumers. So in the first step, an individual consumer, a registered consumer or a trade association files a complaint. Subsequently, the Director General of Investigation and Registration carries out a preliminary investigation for finding the facts in a particular case. If no prima facie case is established, it is dismissed. If the facts favor the case, an action is taken against the complaint. The Commission takes strict action against the accused party for carrying out unfair trade practices and restricts them by granting temporary injunctions. Once the final order is passed, the complainant may also be compensated for his loss. Let's talk about amendments. The 1984 amendment. The MRTP Act was amended in the year 1984 as there were no provisions to protect the consumers against unfair practices such as misleading advertisements which were conducted by the industries. The Sachar Committee in 1978 had recommended that there must be a separate provision under the Act enumerating different unfair trade practices so that it becomes convenient for the producers, suppliers and consumers to identify them and take action against them. Coming to the 1991 amendment, the MRTP Act has been framed in a manner which is effectively able to deal with different type of irregularities prevalent in the market. Before 1991, the MRTP Act effectively regulated the functioning and growth of the large-sized companies with an overall worth of more than 100 crore. It supported them in seeking approvals from the government when establishing new subsidiaries, maintenance of existing companies, mergers and acquisitions, etc. The provisions which facilitated the approvals for the establishment of new subsidiaries, expansion and maintenance of the existing companies from the government, concentration of wealth and power of the monopoly companies and mergers and acquisitions were removed from the Act after this amendment. The major emphasis was laid on the identifying of monopolistic, restrictive and unfair trade practices in order to protect the interests of the registered consumers, producers, suppliers and industries of every size and rank. Now let's discuss some of the landmark decisions under the MRTP Act. The first is BATA. This case was studied in 1975. In this case, BATA had a dominant position in the footwear market in India. It was actively involved in manufacturing of different kinds of footwear. The poor manufacturers essentially involved cobblers and other small-scale manufacturers. The agreements between the parties restricted the small-scale traders to only buy raw materials and souls from the parties and dealers approved by BATA. After analyzing the agreements in question, the MRTP Commission took the view that the acts committed by BATA were restrictive and monopolistic in the light of the provisions of the MRTP Act 1969. According to the Commission, such restrictive trade practices were detrimental to public interest. Agreement also stipulated that they use only those molds that were sold or supported by BATA. The second case is Modern Food Industries 1996. In this case, the MRTP Commission had to deal with a complaint of predatory pricing. Modern Food Industries was engaged in the production of bread and bakery products. It was selling breads at lower prices than the cost of production, so as to attain a dominant position in the market. It intended to eliminate all its competitors. Its ultimate motive was to increase prices after attaining a dominant position in the market. Pricing below marginal costs with an intention to eliminate competition is a monopolistic trade practice. Now let's discuss limitations of the MRTP Act and the birth of Competition Act 2002. Many difficulties were faced while implementing the MRTP Act since its birth in 1969 in relation to the provisions which were considered generic, obsolete and insufficient in dealing with several other offending trade practices. There were several rulings of the Supreme Court as well as the MRTP Commission which expressed the need for stronger provisions. Different cases that came under the MRTP Act revealed the inadequacy of the legislation with regard to practices like bid rigging, cartels, collusion and price fixing, predatory pricing and abuse of the dominant position as well. Many lawmakers and scholars argued that even though there were general provisions against restrictive and monopolistic trade practices, which may also cover all other anti-competitive practices, there was a strong need for identifying specific anti-competitive behaviors in order to protect the consumers and punish the wrongdoers in an effective manner. Another important factor which changed the thought process of government, mainly after 1991 economic reforms, was the marked changes in the international and domestic trade. A stronger and an adequate law was needed to cope up with the progressive changes on the economic and trade front, and this gave birth to the Competition Act 2002, which attempts to promote free and fair competition in India. Now you will find a table which differentiates between MRTP Act 1969 and Competition Act 2002. As you can see, MRTP Act 1969 was based on pre-1991 control regime. However, a Competition Act 2002 was based on post-1991 reforms. MRTP Act was procedure oriented and offending trade practices such as cartels and bid rigging were not mentioned in the Act. Competition Act was more result oriented and these offending trade practices were defined explicitly. In MRTP Act 1969, unfair trade practices were covered and there was a rule of law approach. However, the Competition Act 2002 did not have unfair trade practices as it was removed, and there was a rule of reason approach to deal with the cases. MRTP Act 1966 had no competition advocacy. However, Competition Act 2002 had a high importance for competition advocacy. We will discuss about the cases and the competition law in detail. Now, as discussed above, with the changing perspective of true competition in the globalized economy, it became crucial for India to adopt a competition policy system wherein the objective is shifted from preventing monopoly to one that promotes free competition amongst the market players. From a broad perspective, the changes could also be viewed as an attempt from the side of Indian legislature to modify the Indian competition laws to be in tune with that of other leading jurisdictions of the world. As mentioned earlier, it was also extremely important to remove prevailing trade barriers and restrictions hindering competition in India in the liberalized era. The result was new bill in the parliament. The competition bill was passed by the parliament in 2001 and it became the Competition Act 2002. It received the assent of President of India on January 13, 2003 and it was published in the Gazette of India on January 14, 2003. The Competition Act was partially enforced on 20th May 2009 when the provisions relating to anti-competitive agreements and abuse of dominant positions were notified. In May 2011, the combination regulations were also notified and became operative from June 1, 2011. It's important to note the timeline here since it helps the students to understand how the law evolved. The Competition Act 2002 in its preamble states the following objectives: prevent practices having adverse effect on competition, promote and sustain competition in the markets, protect the interest of consumers, ensure freedom of trade carried on by other participants in the market. The Act provided for the establishment of Competition Commission of India, the CCI, and it started its operation on October 14, 2003. The Competition Commission of India is a quasi-judicial body. The Commission inquires into alleged infringement of the provisions of the Act either on its own or on the receipt of information by any person or a reference made to it by the central government, state government or statutory authority. The orders of the CCI passed under the specific sections mentioned under section 53 of A of the Act can be appealed before the Competition Appellate Tribunal (Compact), and the orders of this compact can be further appealed in the Supreme Court. The Competition Act 2002 covered 4 major aspects of competition law, and as mentioned earlier, the CCI began to execute them in different phases. The 4 aspects are anti-competitive agreements covered in section 3, abuse of dominance section 4, combination regulations, mergers and alliances section 5 and 6, and competition advocacy dealt in section 49. You could see the diagram here. In the first phase, the CCI focused exclusively on competition advocacy. The Commission took extensive advocacy measures by creating awareness and imparting training about the competition issues in many different forums. In phase 2, the CCI started undertaking education works relating to anti-competitive agreements and abuse of dominance. Anti-competitive agreements implies any agreement in respect of production, supply, distribution, storage, acquisition or control of goods or provision of services which causes or is likely to cause an appreciable adverse effect on competition within India. Abuse of dominant position refers to a situation wherein any enterprise or group inter alia imposes unfair or discriminatory conditions or price in purchase of goods or services, limits or restricts production of goods or provisions of services. Now let's discuss some existing case law which the court inquired with respect to the competition law. Bel Air Owners Association versus DLF 2001. In Bel Air Owners Association versus DLF, the CCI issued an order against DLF Limited imposing a penalty of $124 million at the rate of 7% of the average turnover of the company. DLF Limited, a leading real estate company, was found abusing its dominant position and imposing unfair conditions in its agreement with their customers. The CCI found that DLF unilaterally decided to increase the size of the building from 19 floors to 29 without seeking any approval and delayed its completion to the extent where the buyers did not obtain possession of their flats long after the contract mentioned. The Competition Tribunal had stayed CCI's penalty order in Bel Air case. Furthermore, it directed DLF to give an undertaking to deposit the entire fine with 9% interest in case the company lost the case. The ruling conveyed that consumer welfare might be a significant determinant in future abuse of dominance cases. The ruling also initiated the idea of government planning in real estate as a regulator to safeguard the interests of the consumers. The decision was appealed before the compact. Now let's discuss briefly Santuka Associates versus All India Organization of Chemists and Druggists, AIOCD. Santuka Associates had filed a complaint with the CCI in May 2011. According to the complaint, the trade association of nearly 750,000 pharmaceuticals retailers and wholesalers across India was engaged in a widespread anti-competitive activities. These allegations included limiting new entrants into the market, charging the manufacturers a fee to be listed in the association's Product Information Service (PIS), fixing prices and boycotting any manufacturer that did not adhere to these imposed restrictions. The CCI found that this was a prima facie case, and even though the informant withdrew the complaint, the CCI pursued the case ahead on its own. The CCI found that AIOCD's requirement that any new entrant into the wholesale or retail business must first obtain a statement of non-objection from the AIOCD was an illegal moderation limiting the distribution of pharmaceutical products. Moreover, the requirement of fees in order for a drug manufacturer to have its drug listed on the PIS was a restriction on the entry of new drugs in the market and also raised the prices of the drugs to recoup the cost of the fee. The AIOCD's boycott of manufacturers who did not comply with these imposed conditions not only inflated the price of drugs, but also questioned the availability of various drugs to the consumer. The CCI fined the AIOCD about $50,000. In phase 3, the CCI started enforcing provisions relating to combinations like mergers, acquisitions, etc. Certain types of transactions which meet a specified financial threshold under the Act are referred to as combinations and must be notified to the CCI. They are subject to review by the CCI for probable adverse effects on competition. Such transactions cannot be completed until the CCI has explicitly approved the transaction. The transactions, according to this Act, may be in the nature of acquisition of shares, voting rights, control or assets, mergers and demergers, and amalgamations that meet the set of financial thresholds. The enforcement provisions under the Act relating to anti-competitive agreements, Section 3 of the Act, and abuse of the dominant positions, Section 4 of the Act, were notified by the government effective from 20th May 2009, and Competition Appellate Tribunal as provided for under the amended Act to hear the appeals was set up. Now, let us discuss very briefly the notice of acquisition filed by the Walt Disney Company. This was done in August 2011. The CCI approved the proposed combination of Walt Disney Company Southeast Asia Private Limited, which was the acquirer, and the UTV Software Communications Limited within 25 days of receiving the notice in August 2011. This was the first case in the broadcasting sector wherein the CCI approved the sanction on grounds that the broadcasting sector is highly competitive, innovative and dynamic, and a large number of players with strong competition was existing in that sector. So, this is how quick the CCI was to make this decision. Now, let us discuss some additional features of the Competition Acts. This includes effect of doctrine, which gives the CCI power to inquire into anti-competitive practices taking place outside India, but having an appreciable adverse effect on competition in India. Section 32 empowers regulators to extend jurisdiction beyond the principle of territoriality. The Act has extraterritorial reach. Its arms extend beyond the geographical contours of India to deal with practices and actions outside India, which have an appreciable adverse effect on competition in the relevant market in India. The Competition Act 2002 has also specifically exempted certain acts from the purview of the provisions discussed above. This includes the right of any person to restrain any infringement or to impose reasonable conditions as may be necessary for protecting any of her or his intellectual property rights protected under the legislations like Patents Act 1970 or Trademarks Act 1999. The CCI has been vested with immense power to achieve the objectives of the Competition Act 2002. It can issue directions to discontinue or not to re-enter through cease and desist orders in case it finds abuse of dominance, and can subsequently grant interim relief during inquiry. It can impose penalty on producers, distributors, suppliers of up to 3 times of average profits or up to 10% of average turnover for each year of continuance of agreement, whichever is higher, in case of cartel-like behavior, or impose penalty which shall be not more than 10% of the average of the turnover for last years. CCI can also impose penalty on felonious directors and functionaries who are delegated with requisite powers. Moreover, the CCI can declare anti-competitive agreements void. It further possesses the authority to divide dominant enterprise or groups and modify or totally block combinations. The Competition Amendment Act 2007 was passed by the Parliament in September 2007, and it received presidential assent on 24 September 2007. The amendment brought noteworthy changes in then existing regulatory infrastructure established under the Competition Act. The major changes brought in by this amendment included the designation of the CCI. It was initially proposed to function as a judicial body, but could now act as an expert body in advisory capacity to prevent and regulate anti-competitive practices. The Competition Act was amended in 2012. The major amendments approved by the cabinet related to changing the definition of turnover group, reducing the overall time limit of finalization of combinations from 210 days to 180 days. The Act was further amended in 2009 and the Competition Act 2009 received the assent of President on 22nd December 2009. The major changes brought in by this amendment included the transfer of all pending cases under MRTC and cases under the Monopolies Act to the Competition Appellate Tribunal. Competition law and policy in India is emerging. To summarize, it acts as a means to enhance economic development and competition as well as protection of consumers in India. The Competition Act 2002 was put together with the intent to address the shortcomings in the Monopolies and Restrictive Trade Practices Act in the light of the changing economic circumstances in the country. It aims to prevent discrimination and nourish competition in Indian market so as to ensure free and fair trade by all players in the market. Different decisions from the Competition Commission and courts have considerably changed the jurisprudence on this subject within a very short span of time, and it is important for students of competition law to constantly monitor the cases coming up in this area. Thank you so much.